murder, and so on. Now, I have often come across cases where an attorney will refuse to make an admission of that document because they know that you will then have to prove the J88, and to do so will require to call at least 3 witnesses, all of whom are in the employ of the state. They know that that's not easy to do. You will have to issue subpoenas, and then you have to find a way to getting those people into court. They'll have to find the original, which is in a docket somewhere, and so on. So it's quite an onerous task. My opinion is that attorneys who do that, who say, I deny, because they know you'll have a problem proving it, I think that those attorneys are a nuisance and they should be punished with cost orders, de bonis proprius, because they actually have no proper reason, in fact, to refuse the admission. Now, what do you do in that position is that you hold a pretrial conference, you send a copy of the J88 in advance, say we seek admission. At the pretrial, the attorney will say, no, I'm not admitting it. Then you have to say to the attorney, on record, must be minuted, what are your reasons in fact or law for refusing to make the admission? Now, one of 2 things will happen. They will refuse to give you any reasons, or they'll give you a reason that is not sustainable. Something like, what if it's been tampered with? Well, do you have evidence that it's been tampered with? You can't simply say what if. So make a note of that. When you get to the trial, or better still, I would suggest you call for a case conference with the judicial case manager. If you have a case manager appointed, a judge, call on that judge and say, we want to have a meeting. On the agenda will be the refusal to make this admission. In front of the judge, you must then say, I've asked my learned friend for an admission. They refuse. They've not given me a basis in fact or law. And I'm placing on record that unless they do so, I will have to call the witnesses to prove the document. And if the witnesses are not challenged, I will ask for a punitive cost order. You have to do that. And then you do the same thing in opening statement. Now think about it. If you call the district surgeon, who is going to confirm that this is my report, here's my signature, this is what I did, and you say, thank you. He will say, thank you very much. No further questions. What do you think the attorney on the other side is going to do? What cross-examination are they going to do? They're not going to be able to challenge that evidence. They can't say to the district surgeon, oh, you tampered with this document. Well, the surgeon will say, how did I tamper with it? Show me. They're not going to be able to do that. So what this amounts to is an abuse. It's an abuse of process. And that's the point you must take to the pretrial conference all the way to the opening statement in court. And in your opening statement, you will say it. You'll say, my lord, we sought admission of a number of material documents. The defendant refused to make the admission. I'm placing on record that I will prove these documents, but if the evidence goes unchallenged, I will seek a punitive cost order. A good judge will immediately say, or wait till you finish your opening statement, and when your opponent stands up, will say, hold on, Mr. Opponent, tell me about these documents. You are going to add 2 days to this trial. Why do you have any compelling reasons not to make the admission? Now, if your opponent can't answer that question, a judge will then warn this opponent that in the event that you don't challenge the witnesses, I will make a punitive cost order. So now, here's the thing. As lawyers, we are colleagues, okay? But if you find a colleague acting unreasonably or committing an abuse of process, don't be gentle with this colleague. Be professional. Say, I don't accept that conduct. These are going to be the consequences, and make a note of it. Okay? Don't let them get away with it. That was the one question. The other question dealt with hearsay. A talks to B about something. Now, the fact that A spoke to B is not hearsay, because it does not relate to the truthfulness of the content of what they spoke about. But B, if A now wants to say what was discussed with B, that in itself is not hearsay because he was part of the conversation. But if he relates information which is within the personal knowledge of B, which was conveyed to A in a conversation, which A wants to present in court, that is hearsay. And unless B is being called to give that evidence, it will be there will be a sustained objection to that evidence. So however, and I'll come to it. I see I've dealt with it later. Don't be too afraid of hearsay, and I'm going to come to that. I know that sounds ridiculous, but I can assure you, judges are progressively taking a different stance towards hearsay, because very often you object to evidence on the basis that it's hearsay, and it can result in an injustice. But I'll deal with that later. Okay, let me continue with the program. We dealt with the fact that you have to gather all the available evidence at an early stage before you issue the summons. Now, one of the most crucial steps for any litigating lawyer is to carry out a fact analysis. This is now the lawyer's own evaluation of the facts that client presents. Now, there are a number of practical reasons for this. I'll come to them. Yesterday, I dealt with why you want to do a fact analysis. But these days, those of you who are in practices where you deal with personal injury cases, whether it's medical negligence or an accident, road accident or an assault, or practices where you are dealing with damages claims, whether they contractual or delictual, I would say 9 out of 10 times, and very soon it will be 100% of the time, clients will say to you, will you take this case on a contingency? That is happening in every practice. It's very unlikely these days that you can say to a client who comes in with a damages claim, and you say, listen, you have to put down a deposit of so much to cover my fees and disbursements to issue the summons. That's not going to happen, because this client will say, thank you very much, I'll go to the firm across the road. They'll do it on a contingency. Now, step one is the decision to take it on contingency or not. In order to make that decision, you need to look at the evidence. What is the client's case? What you will have to do is carry out what we call a merits risk. a merits risk assessment. You have to work out as a lawyer, if I take this case, what are the possibilities that I can succeed in the damages claim, number one, and number two, if I don't succeed, what are the prospects that I'll get a good settlement out of it? If you can't get one of those two things, you can't take it on contingency. But there's a third thing that comes in now, these days. It's no use winning a case if you can't enforce the judgment. So, I mean, as you know, many RAF practices are in trouble because the fund can't pay. So you obtained a judgment, but the defendant is not paying. If there's a contractual damages, you have to look at the facts and say, will the defendant be able to satisfy the judgment? If not, you can't take it on contingency. And as I told you, if you so much as smell that this is a vexatious litigant, don't even think about contingency. You say to that person, I will expect a deposit. This is the amount. I want it paid into my trust account. That's the only way to get rid of them. If they pay, fine. Then your job is to debit out as much as possible, as fast as possible, and ask for another deposit. That's what you do to those people. So fact analysis, now I'm going to explain, is confined to the case itself. Your best preparation of the evidence starts with a fact analysis. It is crucial for litigation. Without it, you are likely to run into a risk of a poor outcome. So I'm going to show you the steps that you need to take. I say you cannot possibly conduct any litigation without carrying out a fact analysis. Now, here's a fact. Those attorneys and advocates who draft particulars of claim with a poor knowledge of the facts, they are the ones who draft from a precedent. And right there, you're in trouble. From the start, you're in trouble. So there are 10 basic steps. I'll go through these quickly because we've discussed it already. First, get all the facts. Second, sequence the facts. Sequence the documents. Those of you who are in commercial practices, clients bring you a box full of documents. Okay. Now, in the modern era, you will not get a box full of documents. You will get a hard drive, or you'll be given access to the cloud, where your client would have stored the documents in the internet. There's software that you can use, which will help you to search the database and pull out documents that are relevant. What you cannot do anymore is discover the whole lot, okay? That's ridiculous, and you won't be allowed to do that. Evaluate all the material facts applying the RAP test. That's the 3 yeses. Must be relevant, must be admissible, and the version must be probable. Then make a note of those facts that support your client's version. What are the facts that support your opponent's version? Now, you're supposed to write this down. Now, after you write it down, take a pen, a red pen, or you can do it with a red marker on your computer, or red highlight. Make a note of the best facts for your client. From the list of good facts, what are your best facts? It's what the lawyers call the bullet points. What are your best facts? Mark those. Now go to the other side and look at the worst facts. and say, which of these bad facts are my worst facts? Now, you have to then write that down. Now ask yourself, how can I present evidence or proof of my best facts? Well, you will find it in your witnesses, in your documents, in your visual evidence. Then you have to work out, how can you reduce the impact of the worst facts? Can you undermine the witnesses of your opponent? Is there a basis to undermine them? You have to, the facts have to be found, preserved, and ultimately presented at the trial. This is the most effective method of preparing the evidence. Now, I can assure you, if you're not doing it this way, you are skating on thin ice. And you know when you'll find out? You'll find out on day one of the trial that you're in trouble. So now let's look at a classification of the facts and how you deal with them. In any trial, the evidence will consist of the following facts. Facts that are common cause. Now, this is easy. Everyone can deal with this. This is where the parties agree. The incident took place on Tuesday, the 24th of August. Nobody disputes that. Common cause. Then there are facts that are admitted. Facts which were not initially, or which are not common cause, and which were potentially disputed, now become admitted. This is a very important method that we use to reduce court time. Now, be warned. If your opponent calls on you to admit a fact, consider the effect of admitting that fact to your case. Does it undermine your case? Or is it not material to your case? But most importantly, ask yourself, do I have a basis in fact or law to challenge that fact? Very often, when you dispute a fact, that may be one of the issues, and you are perfectly entitled not to make the admission. But if you know that you have no basis for refusing to make the admission, I'm just warning you, be careful, you'll pick up a punitive cost order. Then you have facts that are undisputed. Now, so I often get asked, so what's the difference between undisputed and admitted and common cause? Aren't they the same thing? Well, they're not. An undisputed fact is a fact which prima facie your opponent says, I deny. So it's disputed. But in our law, this is the procedure, and trust me, if you get this wrong, you will get into trouble. It is part of our rules of evidence now. Our courts, in the process of resolving disputes, do not tolerate bare denials. This thing of I deny, not tolerated anymore. If you say I deny, you must say why. What's the basis in fact for that denial? If you have no basis, then it's an abuse to say I deny, you prove it. But then when your opponent calls a witness to prove it, what happens? You can't cross-examine. Why? Because you have no basis in fact for the cross-examination. So you stand up and you say, well, the opponent says, my lord, I have no questions for this witness. The judge will have no difficulty. You don't have to invite the judge to make a cost order against such a person. Now, but be very careful. There are some lawyers who will cross-examine. Let's take our district surgeon who says, this is my J88 and I want it admitted into evidence. There's no basis to challenge it, but you'll get some lawyers who will cross-examine. It's just a smokescreen. They're going to stand up and they'll say to the surgeon, doctor, where were you trained? Which university? And how long have you been in practice? Now, when did you join the Department of Health? And how long have you been a district surgeon? Questions like that. And then the lawyer looks at the judge and says, well, my lord, I have no further questions, and looks important and sits down. Well, don't tolerate it. That cross-examination took it nowhere. It's not a challenge to the admissibility of that document. None of the questions asked bore any relevance to the admissibility of the document. So don't fall for that trick. And by the way, don't play that trick either, because you will pick up a cost order. And you know, trial technique is about getting the judge to listen to you. Now, if you stand up in court and you pull these stupid tricks, the judge stops taking you seriously and you're on the back foot after that. The judge doesn't like you. You're here to take a chance. I'm not listening to you anymore. That's what happens. And then you get facts that are disputed. Now, this is where the issue lies. There will be issues of fact and issues of law. The disputed facts will comprise the actual issue between the parties. And that has to be resolved by the presentation of evidence, and the judge makes a finding. Now, the undisputed facts, I told you, are equally important. So you will make a list. On one list, you write down the facts that are common cause, the facts that are admitted, and those facts that are undisputed. Those facts which your opponent has no basis to dispute. Okay. Why you need to write it down is because you will use that as a framework to do two things. Firstly, you will use it as a framework to determine the probabilities of your own version. And the test is simple. If these facts that are now undisputed support your version of what happened, you are good to go. You've got a good version. If it does not support it, you've got a problem. That is exactly what the judge will do. They assist you in establishing the actual issues between the parties. And it helps the judge to do that. And when you write heads of argument and present final argument, there's no more powerful an argument than to say to a judge, my lord, you can make the finding based on the undisputed facts. Judges like that because they can make a finding and know that it's not going to be challenged. They are absolutely essential to resolve disputes of fact. Where there is a dispute of fact, it is the undisputed facts that help to determine which party's version is more probable and therefore more persuasive. Now, this is a technique you must never forget. For as long as you practice, always think like a lawyer. This is thinking like a lawyer, and there's a logic in it. Surely, if your client says this is what actually happened, and then you test that against the undisputed facts. It's like our example. Your client tells you, oh, I was doing 60 Ks an hour. And then you see he left a 25-meter skid mark, which is evidence of emergency braking. under circumstances where he was traveling too fast. Now, you cannot put the two together. What it means is that your client's version is improbable. In fact, it could be an outright lie. And now I come to something which is absolutely vital for you as lawyers. Most of you, in fact, all of you, will be practicing in the motion court, unopposed and opposed. Unopposed motions is your bread and butter. You've got to do that in any practice. My book on trial advocacy deals with this in detail on how you practice unopposed motions and opposed motions. But now let's forget about the unopposed motions. In opposed motions, you file 3 sets of affidavits. There's a founding affidavit, an answering affidavit, and a replying affidavit. Now, what happens in those affidavits is that the applicant sets out the material facts that make up their cause of action in law, and it contains the evidence that supports or proves those material facts. So in a founding affidavit, unlike in particulars of claim, where you only have to plead the material facts of your cause of action, that's the facta probanda. In an affidavit, you have to also present the evidence, the facta probantia. So what happens then is that the respondent has to respond to the answering affidavit and provide a defense and the supporting evidence. And then there's the replying affidavit, which the applicant needs to deal with. One of the problems that we have in the opposed motion court is that very often respondents turn up, put up a version merely to create a dispute of fact, and then they tell the judge, look here, the applicant used the wrong procedure. They should have gone by way of action, dismiss the application. Or they'll say, your lordship cannot resolve this dispute on affidavit, refer the matter to trial or the hearing of evidence. Well, that's an old trick. It's one of the oldest tricks, where you set up an answering affidavit with a whole lot of disputes of fact, only to delay the matter. That's another abuse. Judges have found a way to deal with it. And it's called the Plascon test. So judges are aware that in order to manipulate the evidence, the respondent will create disputes of fact. Many of these disputes are non-meritorious. They're just being raised as disputes and denials and so on to delay judgment. Judges know it. It's one of the oldest tricks in the book. So how do they deal with it? They've developed what is today known as the Plascon test. Now, the Plascon test, it gets its name from the decision. It's on the screen. Plascon Evans versus Van Riebeck Paints. It's 1984-3. Now, the reason it's called the Plascon test is because of Plascon. But I'd like you to read this judgment, but don't bother with the facts. It's a judgment which deals with, you can tell, it's a dispute between 2 paint companies, and it dealt with patents. It's a patent dispute. But in that judgment, you will see 2 other decisions which preceded this. They are both called Stellenbosch Farmers Winery. There are 2 cases of two judgments there. Read those judgments. It tells you how to resolve disputes of fact. Now, In motion proceedings, where a dispute of fact arises on the affidavits, a final order can only be granted if the facts averred in the applicant's affidavits, which have been admitted by the respondent, together with the facts alleged by the respondent, justify such an order. That's the test. What is it about? If you read that carefully, it's about the undisputed facts. The judge is saying, let me analyze these affidavits. What is the dispute raised by the respondent? Okay, he gives a story, he gives a version. And by the way, even in motion court, on the affidavits, judges will test the probabilities of the version that is stated in those affidavits. You should do the same. The moral of the story, never write a story in an affidavit which is improbable. Firstly, it's going to be disbelieved. When the Plascon test is applied, you lose. Number two, if the version is improbable and you put it in an affidavit, you are potentially exposing your client to a charge of perjury. You don't want that, okay? So don't do it. In motion proceedings, if your client's got a rubbish version, say to him, settle it, okay? Or issue a summons for what that's worth. But don't go by way of motion, okay? So take the facts, the evidence in the applicant's founding affidavit and ask a simple question. Which are the facts that are not disputed by the defendant or respondent? Make a note of that. Now combine those facts with the respondent's version and ask yourself, can I grant an order? What this means is when you look at the respondent's version, you're going to ask the following question. You're going to say, which denial in the respondent's answering affidavit has a basis in fact for the denial? If it's a bare denial, the judge puts that on the undisputed side of the scale. If it is disputed and a version is given, the judge says, firstly, how material is this dispute to the issues between the parties? Very often, respondents put up disputes which are not really relevant to the main issue between the parties. And once the judge sees that, the judge disregards the dispute and then finds that he can grant the order. So here's a tip for you. When you draft affidavits in motion court for opposed motions, where you see that the matter is potentially going to be opposed, always bear the Plascon test in mind, because good lawyer will be ready to argue that the Plascon test must be applied and it will favor the applicant. That's what you do. Now, the way you deal with evidence in a motion court, post-motion court, is very different. Remember, you have no opportunity to lead, to cross-examine, and the judge has no opportunity to listen to cross-examination or to observe the demeanor of a witness and so on. So these are the methods that we use. Merely analyzing the facts. What is disputed? Is it a bona fide dispute? Now, it's a bona fide dispute if the dispute is supported by a probable version and relevant facts. Now it's a bona fide dispute. The judge will say, okay, I can't resolve this on paper. I'll refer you to trial. Now, here's a warning. Never put your foot in an opposed motion court if you don't know the Plascon test and how to apply it. You are going to be embarrassed. I've seen it in court many times where either the judge or one of the counsel say, well, my lord, if you apply the Plascon test, this is the result you get. And you're sitting there wondering, what Plascon test is he talking about? I mean, it's really embarrassing. So don't be stupid. Go and understand the Plascon test, because it tells you how to handle the evidence in motion proceedings. Okay. Now, the benefits of fact analysis, I can go through this quickly. We've dealt with most of it. It uncovers and helps you to preserve the key evidence. What's the key evidence? The material facts which are supportive of your case. Once you have the evidence at an early stage, you will be able to secure it for the trial. So documents can be preserved, witness statements can be taken and signed, you will keep in touch with witnesses, you will protect evidence from being destroyed, and all that's really what a good trial lawyer does. Fact-finding, early fact-finding, gives you an insight into the strengths and weaknesses of your case. Those of you who are in contingency practices, take note. This is what you have to do. The fact analysis will help you to advise client at an early stage and avoid wasted cost. Now, here's another thing that we expect from lawyers. This is the 21st centuries, okay? You don't go to court simply because you can. You go to court because you have a genuine dispute and you have merits. Every lawyer is under a duty. It's a professional duty. It's an ethical duty to tell client what the strengths and weaknesses of the case is. You have to advise client on the possible outcome based on the evidence that you have. You can't ignore it anymore. We used to ignore settlement previously, but now you are forced to apply your mind to settlement. And good fact analysis reduces unnecessary expenses and it saves time. And also, when you've done fact analysis, before you issued the summons, your particulars of claim will be of a better quality. You will have the confidence to go to court or go to a pre-trial conference in order to deal with your case. You will manage your opponent perfectly. There are some lawyers who are terrible people when it comes to as opponents. It's unfortunate, but they're still there. There are many of them in Johannesburg. You'll find them in all the big cities. Oddly enough, this doesn't happen in the small towns. If you're practicing in Ermelo, or Newcastle, it doesn't happen there. It's because the attorneys know each other. They're all drinking buddies and they settle everything. But in a city like Johannesburg or Durban, where attorneys can get adversarial, they can be awful opponents. My advice to you is don't tolerate them. You don't have to lose your temper. You don't have to adopt an adversarial view. You just deal with it professionally. You make it plain to your opponent, I'm not tolerating that, and these are the consequences. Understanding the legal principles, very important. Remember, any set of facts or evidence that is presented to you doesn't come with a classification, okay? Your client doesn't say to you, this is what happened, and this is a delictual claim for damages. They don't tell you that. But that client is never going to say to you, listen, this is what happened, and I have a claim in unjust enrichment against the defendant. They don't tell you that. They tell you a narrative. You have to classify that evidence into a legal pigeonhole. That's the first step in drafting your cause of action. You will be able to identify problems in your client's legal and factual position. It helps you to identify the material facts you need to sustain your cause of action. You will avoid motions of exception. Now, I've seen particulars of claim over the years drafted so badly. You wonder where this person was educated. There's no visible cause of action. There's no material facts. It comes out of a precedent. Okay. So I told you all of this has to be done before you issue a summons or file a plea in a civil case, before you enter a plea in a criminal case. With criminal cases, you've got no excuse because you got everything. You got the witness statements, you got access to the exhibits, you've got the state's case. Okay. Except these days, it seems that there may be another docket that you don't know about. It's quite bizarre, this Senzo Meyiwa trial. Now, let's think about the probabilities there. If there are two dockets, the docket that's in court is a docket that says these 5 accused are the culprits. They murdered the soccer star. But now there's another docket which has different suspects. What are the probabilities that they got the 5 wrong ones in this trial? Now, that's exactly what came up in court yesterday. I mean, it's such a botch up, okay? The prosecutor did not do a proper fact analysis because then he would have come across the second docket. The prosecutor's response was bizarre. He says, oh, I didn't know there was another docket. So now it means that there was a different investigating officer as well. I mean, it's just bizarre. Okay. Now, under the new case management regime being introduced in our courts, fact analysis is indispensable. Now, can you imagine? I don't know if any of you have had the experience of attending a case conference with a judicial case manager. In other words, with a judge. You know that we've started this thing called the commercial court. Not started it, we restarted it. We used to have it back in the 80s, but it didn't work. We started it again. The idea is to get business back into our courts because South African business has fled from our courts. There's no commercial cases on the trial roll anymore. I mean, really, not even one. It's all gone to arbitration. So, in the commercial court, a judicial case manager is automatically appointed if you ask for your matter to be transferred to the commercial court. If you are not in the commercial court, you will have a case you can apply or write to the DJP or JP and they'll appoint a case manager. Some of you may have seen the new practice directive on the family law courts. At last, we are now going to have family courts that deal with family law matters, divorce, maintenance, custody, access, all that stuff. It sits, 2 judges sit in a family court all the time. I think they spend a week in that court, and next week there'll be 2 more judges. If you read those directives, they provide for the case management of those matters that are disputed. The family court is long overdue, and it requires case management. You know, the worst culprits when it comes to family law are not parents, it's not the couple, okay? It's not the mother-in-law, it's the attorney. The attorneys are the culprits. They are the ones who stretch this thing, incur costs, create huge files over nothing. Well, I can tell you, it's not going to be tolerated anymore. So, when you do a proper fact analysis, then you can confidently go into a case management with a judicial case manager. If you don't know the facts, trust me, you are going to be embarrassed in a case conference, because the judge will say, well, what is your position on this? And you don't know, because you don't know the facts. So you're going to say to the judge, well, judge, I'll have to take instructions, and revert. The judge is going to say, but hold on, you're the attorney or you're the advocate. Why do you need to take instructions on this? Where were you all this time? Were you sleeping? Okay, you will be embarrassed. So do the fact analysis. So now I'm going to go to, so far we concentrated on the facts. That's what evidence is about. But you cannot ignore the law. So we're going to deal with some law of evidence now. But I'm going to take a very practical approach to it. The law of evidence, or the rules of evidence, because that's what they are, govern how and in what form facts may be presented in court so as to be admissible as proof of a fact. That is what happens in court. Why do you lead evidence? You lead evidence in order to provide proof of a fact. What fact? A material fact which is material to your legal cause of action and which is in dispute. You have to provide proof of that fact in order to succeed in getting the remedy that you want. The law of evidence governs the proof of facts in court and forms part of our procedural law that makes substantive law effective. This is what we call adjectival law. What are the functions of the law of evidence? It determines what facts are legally admissible to prove facts in issue. What manner should the evidence be adduced? Now, you can adduce evidence in various ways. Call a witness to testify, that's oral evidence, which is the most common form. But there are other ways. You can hand up an affidavit. That's one way. You can hand in a signed statement. And then you can use visual evidence. It tells you what evidence may be withheld from the court. Evidence that is unlawfully obtained cannot be presented in court. That is the case because we are now a constitutional democracy where everyone is entitled to a fair trial in an open court. Evidence that is illegally obtained cannot be used in an open court as against a litigant. That is why you cannot use evidence that you obtained because you illegally tapped someone's telephone or you hacked into their computer. The rules of evidence say you can't do that. What rules may be taken into account in assessing the weight or cogency of evidence? Okay. This sounds like university again. Cogency of evidence or weight simply means the value you put on a piece of evidence as proof of a fact. Okay. That's what a judge is asking. So that is what is meant by the probative value of the evidence. Now, what standard of proof must be satisfied before a party bearing the burden of proof can be successful? Now, that's a question of onus, and we'll deal with that in more detail. Now, the facts in issue are those facts which a party must prove in order to succeed. Now, you'll typically find this in pleadings or in a charge sheet, and it is commonly described as the elements of your claim or the elements of the offense. Now, that's what we learned at university. We used to say elements of the claim. But no one told you what is meant by elements. I don't know why they use that term elements. All it means is the material facts of your claim. When someone says elements, they mean the material facts. And then you have to provide the evidence to prove those material facts. Facts which are relevant to the issue are those facts which tend to prove or disprove the facts in issue. And we call this the facta probanda, the material facts that you need to prove in order to sustain your cause of action. So, what are the various types of evidence you will typically find? There are 4 categories. You have direct evidence, which is the most persuasive evidence, eyewitness account. You have indirect evidence, which is circumstantial evidence or fact-finding by inference. So instead of a witness coming and saying, I was present when the defendant drove his car through a red robot. That's direct evidence. But very often, there is no witness. There's no direct evidence. Like somebody's being charged with burglary. There was no one at home. No one saw it. So how do you prove that it was the accused? By using circumstantial evidence. You found a fingerprint that matches him. You have a footprint of his shoe found in the house. You found his DNA in the house. You found property that was taken from the house in his possession. So you piece all this together and then you say the only reasonable inference to be drawn is that he was in the house and he was one of the burglars. So that's circumstantial evidence. Then you have evidence of credibility. What this does, it establishes the credibility of the other witnesses, the direct and the indirect evidence. So it's corroboration, it's supporting evidence. Now, there are some versions that require supporting evidence, evidence of credibility. For example, the most famous defense in a criminal case where the accused says, I was not there, I have an alibi. Now, an alibi version requires evidence of credibility. The accused says, at that particular time, I was at work. That's not good enough. You'll need supporting evidence, evidence of credibility. You'll have to call an employer to say, on that date and time, this accused was at work I saw him there. Here is his clock card. It was clocked in or he signed in. He could not have been at the bank when it was robbed. So you need supporting evidence. Then you get the fourth type, which is expert evidence. Now, this expert evidence is not factual evidence. It is opinion. The expert is providing his opinion. Therefore, we don't call it factual evidence. The other three is factual evidence. Okay, and we'll come to experts in a moment. So the most persuasive evidence is direct evidence, where you rely on a credible eyewitness. People who can testify from their own knowledge. That's the best evidence you can lead. Okay, so you always look for an eyewitness. Where you are faced with an opponent that presents direct evidence that does not favor your client's version, be prepared to respond. Because now you have to find a basis to undermine this evidence in cross-examination. If you don't, then it's going to damage your case. Now, here are some suggestions. You have to take your client through the pleadings, or in a criminal case, the state witnesses' statements. Concentrate on every detail of the evidence. Like they say, the devil is in the detail. The detail comes in when you're cross-examining, or when your opponent or the judge or you have to test the probabilities of the version. The details are important. So what is your client's response to this? The defendant says that's not his signature. What do you say? How do we prove that it is his signature? Who will provide proof? Will we need an expert on handwriting? What is your version of the facts? Now that you've seen the other side's case, how does it affect your case concept, your version of what happened? Now, the question that most lawyers find very difficult in a criminal case is you read a statement and you say to the accused, your client, why will this individual implicate you in this offense? What is his motive to falsely implicate you? Or in a civil case, why is the plaintiff suing you? If you know nothing about this claim, why are you being sued? Why did the plaintiff choose you, of all people, to sue? In a criminal case, very difficult to find an answer. Okay? That is why most criminal cases, I'd say about 8 out of 10, the accused will instruct his attorney or advocate not to make a plea explanation. Okay. Now you know why. You must always test accuracy and knowledge of the facts. That's what a good lawyer does. How do you know that? Why do you say it's the defendant? Do you know the defendant? Are you seeing the defendant for the first time? Why do you say that this is the defendant's signature on the surety slip? How do you know? Were you present when the surety signed? Do you have samples of his signature? Has he signed other documents? Test all of that. That's the detail. Always test if your own witness's version is probable. Ask if your client's response is probable. Like the client will say, oh, I don't know that. I've never heard of it. I deny that. Well, tell me why. And then ask if that version that you get is actually likely to have happened. your own client's denials of your others, the respondent or the defendant's material facts, must have a factual basis. If your own client says, no, I deny that. Why? No, just deny it. We don't do that in court. You must have a reason for denying it. Tell me what the reason is. If you don't have a reason, how am I going to cross-examine the witness who presents that fact? You have to ask. Never accept bare denials from your client. And a good lawyer will always explain the consequences of a bare denial. You see, otherwise clients seem to think, well, you're not really fighting for them. I'm telling you to deny this thing. You're saying, no, I must give reasons now. You have to explain it to them. They are lay people. All evidence led in court involves some form of inferential reasoning on the part of the judge. Now, that is part of the adversarial system. Why? Because the judge doesn't investigate the facts. The judge hears the facts, hears the evidence from the lawyers and their witnesses. When a judge hears a version, the judge doesn't sit and say, oh, okay, that's a nice story. The judge has to decide, what does that version mean? What are the inferences that I can draw from that version? The plaintiff actually knows the defendant. They went to school together. The inference I can draw from that is that the plaintiff is not likely to have made a mistake in identifying the defendant. You see, there's inferential reasoning. With direct evidence, the judge draws inferences as to the truth of the testimony. This happens with all three of the categories that we dealt with, that's except for experts. Circumstantial evidence is very important, especially in a country like this one, where you don't get direct evidence, not because there was no eyewitness there that you can access, but because there were eyewitnesses. They're just not willing to testify. And when I come to the Law of Evidence Amendment Act, I will deal with this. I would say in more than half the cases you deal with, the state or your opponent in a civil trial will not have direct evidence to prove their case. They will rely on indirect evidence, what we know as circumstantial evidence. Now, with a judge, once a witness is found to be truthful, or to put it differently, when a judge is persuaded that a witness is telling the truth, then the judge engages in a different set of inferential reasoning in what is called circumstantial evidence. Now, I'll come to how that reasoning works and how you should deal with it in court. Your opponent will be presenting proof of a certain fact through inferences to be drawn from a number of facts. So just to give you a simple, go back to our court case, our example of the motorcar accident. The defendant can prove that, in fact, it will be common cause, that the speed limit on that road is 60. It's in an urban area. The road is tarred. The weather was fine. The road was dry. The robots were working. The car left a skid mark of 25 meters. Now, what are the inferences that you can draw from that? The inference that can be drawn is that the driver of that car applied emergency brakes. Otherwise, it is not, that car is not likely to have left such a long skid mark. Why was it necessary to apply emergency brakes? The inference that can be drawn from the length of the skid mark is that the driver was going at an excessive speed. Now, do you see how the facts emerge from inferential reasoning based on circumstantial evidence? Now, this happens in our courts all the time, and it is a very useful weapon to use in an adversarial hearing. Now, I'm going to go through some practical suggestions, seeing as circumstantial evidence is going to, you will confront this from time to time. In a criminal case, read through the docket. See if the state is relying on circumstantial evidence. Now, that's very easy to work out. If there's no witness statement in the docket of direct evidence where the witness can say, I was there, I saw what the accused did, I saw the accused stab the deceased with the knife. Now, where you have no statement of a witness who can give direct evidence, the state will be relying on inferential reasoning. So, for instance, the state will have a witness, or could be an investigating officer, who will say when he arrested the accused had blood on his clothes. The blood was tested and it matches the blood of the deceased. A knife of the type used to inflict the wound that we see on the body of the deceased was found in the accused's car. There was traces of blood on the knife. It matched the blood of the deceased. Another witness comes and says, the day before, he saw the accused and the deceased arguing over money. It appeared that the accused owed the deceased some money, and the deceased and the accused were involved in an argument. Right, now, put all that together, the prosecutor will say, motive has been established, the link between the accused and the deceased has been established, cannot be disputed that the blood is the blood of the deceased, found on his clothing, found on his on the knife. The wound on the body matches the knife. So the inference to be drawn is that it is the accused who stabbed the deceased. You see, this can happen in civil cases as well. Now, how do you deal with it if you're on the receiving end of circumstantial evidence? There's a method. What you do is write down, and by the way, I always say write down. There's a reason for that. When you write, that's when you think. When you're copying and pasting, you're not thinking. You're a moron. When you are writing on your own, you are forced to think. You are going to think like a lawyer. Write down the names of those witnesses that the other side will be using. Next to that name, write down the material fact that comes out of that evidence. Now you will see a picture in front of you. What you will see are the facts which your opponent will present to the judge, and the question will be asked, what inferences can you draw from this? If you can draw another inference, reasonably draw another inference, which is not the same as your opponent's, your opponent is not likely to succeed because that doesn't amount to proof. So the inferences provide proof of a person's guilt. You have to apply the test in R versus Blom. It's been around for decades. It's a 1939 AD case. Explain to your client what is meant by circumstantial evidence. You know, your client will say, there's no evidence. No one saw me do this. Look at the evidence. This establishes that there's a direct connection between you and the incident. How you approach this now is you take each statement of the witness. Say there are 5 witnesses. Take each one and see if you can undermine credibility and reliability. Now, the trick is you don't have to destroy all five witnesses. All you have to do is undermine maybe 2 of them. If you can undermine the fact that the blood samples were not collected properly, they were tainted, and the test is unreliable. If you can just damage that one fact, the inference can't be drawn. Do you see? You don't have to damage all 5 witnesses. You damage just the one. You cross-examine the witness who saw them arguing. So you don't know why they were arguing. You thought it was for money. The accused was not violent towards the deceased. It was just an argument. So you've undermined the motive part of it. So what you have to do is undermine sufficient fact so that you can say that the inference to be drawn cannot be made. Okay. So that's how you deal with it. So prepare your strategy on the basis of damaging some of the witnesses. You don't have to damage all of them. In order to argue that the required inferences and probabilities cannot be made to support a conviction in a criminal case, note that the court cannot treat each circumstance in isolation. A judge will consider the cumulative effect of the circumstantial evidence, and that's very important. With evidence or fact-finding through inferential reasoning. You cannot isolate the facts. You have to look at all the facts together and then say, can a reasonable inference be drawn? Now, each of the circumstances must be proved beyond reasonable doubt in a criminal case or on a balance of probabilities in a civil case. In a civil case, the proved fact should be such as to render the inference sought to be drawn more probable than any other reasonable inference. Now you see, the balance of probabilities. We're back to probabilities. The judge doesn't know what happened. What the judge will say, if these are the circumstantial, this is the circumstantial evidence, what are the probabilities? What are the probabilities that the inference to be drawn did not happen? If they allow for another more equally probable inference, then of course, your opponent will not succeed. And now we come to evidence of credibility. Now, this is absolutely essential for a trial lawyer. And it is also essential in opposed motions, because the issue of credibility does come in when you're applying the Plascon test. So what is evidence of credibility? It takes the form of a witness who is called to support a direct or even an indirect witness. The witnesses are called in corroboration. Corroboration makes it easier to conclude that the required standard of proof was met. That is why judges want corroboration. It's because it makes it easier for them to say that is likely to have happened. The party bearing the onus has discharged the onus. Okay. But please remember, you don't always have to provide evidence of credibility. I'll come to that in a moment. Let's look at some practical suggestions. Where a direct witness, that's your eyewitness, performs well, a good lawyer will not call a supporting witness. And that's the point I was going to make. Let's say, now one of the things you do in court is you always kick off with your best witness. Now, your best witness will be the one direct witness who has personal knowledge and was on the scene. So you can testify from personal knowledge, eyewitness account. But you've also got two other witnesses who can say they were also there and they corroborate what the first witness said. Now, if you have your first witness cross-examined and the witness performs really well, and you can see the judge is with this witness, the judge likes the evidence, you can only do damage if you call a witness on credibility. Don't call the other two witnesses. Because if you call the second witness, you have no control once they're under cross-examination. The second witness might contradict the first witness on a material fact. And now what you've done, you've gone and undermined your best witness with your second witness. Good lawyer will tell the other two witnesses, not necessary to call you, you can go home. You only call the next witness if the first one did badly. You want to support this witness. If that witness doesn't need support, then don't give them any support. Where a witness in support is called, let's say you're the opponent and a witness in support is called, look for a weakness in the first witness's version and base your cross-examination on that. So in other words, you attack the credibility of the first witness by cross-examining the second one. That's a very good technique, and it causes damage to your opponent. The same test applies to your client's case. If your client performs well, you may consider it not necessary to call a supporting witness. Okay. With some defenses, such as an alibi, you are absolutely compelled to call a witness in support. Okay. You must call a supporting witness, make certain that you consult carefully, dealing with the details. It can be fatal if your supporting witness contradicts the direct witness in material terms. Now, when it comes to alibis, remember we discussed it earlier that you must sequence the events. Chronological sequencing is vital. Now, I've seen lawyers in criminal courts where the client relies on an alibi. I was not there, I was somewhere else. They fail to sequence the facts. And then what happens? Under cross-examination, it soon turns out that your supporting witness, the one who can corroborate your client's alibi, just happened to be in two places at one time. So it just gets discredited. Always sequence the events. And if the supporting witness's evidence is not supported by the sequence, if it is out of sequence, it simply means it's improbable and it's discredited. You are in trouble. Don't call that witness. If you call a witness in corroboration, it is preferred that the corroboration must emanate from a source independent of the witness who stands to be corroborated. There's a rule against self-corroboration. That's what it means. If you call a witness to corroborate who has a bias, who has an interest in the outcome of the case, this is what is called self-corroboration. And why is there a rule against it? Simply because that kind of evidence has no probative value. It has no weight as proof of a fact. There's no point in leading it there. And now we come to a very important aspect of evidence. It's the onus. Now, with criminal cases, the onus is on the state. There's never any doubt about that. You know that post-Constitution, all of those presumptions that were in favor of the state have now been outlawed as unconstitutional. For example, in the past, if you had more than so many grams of dacha in your possession, you were presumed to be a dealer. And then you have to prove that you were not a dealer. So those things we've done away with. So the onus is on the state. As I told you, the reverse onus caused by presumptions in favor of the state have been purged from our statutes. The position is not so easy in civil cases. Okay. Now, when it comes to onus, I've broken this up into simple rules that you can understand. Rule number one, if one person claims something from another in a court of law, then he has to satisfy the court that he is entitled to it. Okay? That's like saying the plaintiff bears the onus. Rule number two, where the person against whom the claim is made is not content with a mere denial of the claim, but sets up a special defense, then he is regarded quoad that defense as being the claimant. For his defense to be upheld, he must satisfy the court that he's entitled to succeed. This is the confess and avoid, where the surety says, I admit my signature, but I deny I signed it freely and voluntarily. I signed it under duress. The plaintiff threatened to have me arrested and locked up if I did not sign. The onus to prove the duress is on the defendant. Rule number three is the famous cliche. He who asserts proves and not he who denies. Since a denial of a fact cannot naturally be proved, provided that it is a fact that is denied, and that the denial is absolute. Now, go and read two cases. There's the Intramed case, it's in your notes, and Pillay versus Krishna. You have to consider onus and evidentiary burden. They are altogether related. The onus of proof is a duty on a party, is a duty a party has of finally satisfying the court that he's entitled to succeed on his claim. So in other words, the party that is claiming relief based on a cause of action bears the onus of satisfying the court that he has presented proof on a balance of probabilities of the material facts that make up his cause of action. The incidence of onus decides which party must fail on a given issue. After hearing all the evidence, the court is left in doubt. Now, that's the function of onus. If the court, after hearing all the evidence, can't decide whether to accept the plaintiff's version, or to accept the defendant's version, or to reject one or the other. In other words, the quality of the evidence is not such that the court can say one or the other party has discharged the onus. This is what we call, or what Wigmore called, the risk of non-persuasion. I think that's a brilliant description, the risk of non-persuasion. If you are unable to persuade the judge and you bear the onus, you lose. Simple as that. You must have heard of absolution from the instance, where a plaintiff presents all the evidence, but has failed to provide proof of a material fact that makes up his cause of action. The other side needn't even respond. They apply for absolution and it's granted. Okay? Always, when you walk into court, never lose sight of the onus. Getting it wrong can be fatal. Knowing the onus as a defendant, you must know that the plaintiff has the onus. And if the plaintiff is not unable to discharge it, you win. But you'll have to tell the judge that, look here are the material facts that the plaintiff failed to prove. There's no proof of these facts. They have not discharged the onus. Dismiss. Okay? Now, it's 12:30. This is a very interesting topic that worries most lawyers, is when do I close the case? Okay? When do I lead evidence? When do I close the case? And it's a problem in both criminal and civil proceedings. So take a 10-minute break now, and we'll resume in 10 minutes, okay? Yeah, okay. 10 minutes. All right. Betty, can we carry on?
We can continue, Judge.
Okay, right. Betty, I see a lot of questions coming up, but they flash on the screen. I can't read them fast enough.
Not to worry, I will send him to you,
Okay,
sir.
all right. Now, there's a whole, in your careers, you will be faced with this problem where at the end of your opponent's case, you have to decide whether you should close your case or proceed to call your first witness. This is not such an easy decision, okay? Now let's deal with the criminal cases first, because it's a lot easier there. If the state led evidence that is damaging to the accused, then the accused has to answer. It's not enough for the accused to have put a version to the state witnesses, which is essential in our system, and then not support it with any evidence. If you close your case, then you only do so if you are satisfied that there is a fatal gap in the state's case, so you can say there is no proof beyond reasonable doubt. Now, with criminal cases, the question often asked or confronts lawyers is, at the end of the state's case, do you ask for a discharge in terms of Section 174? Or, secondly, do you close and argue then that there was no proof beyond reasonable doubt? Now, the problem with discharge, the 174, is that if the court refuses it, and now you think, okay, then I must close, the judge or the magistrate may well draw the adverse inference that may work against you. My advice is, in criminal cases especially, you know that if you call your witnesses, or if you call the accused in a criminal case, you have to call the accused first to testify. It's in the Criminal Procedures Act. You know that if you call your witness to testify, that's the accused, he's going to convict himself. So if there's a gap in the state's case, all those gaps are going to be closed because of your own client's performance in the witness box. You know that. The better option is not to ask for a discharge. Just close your case. In fact, you should stand up as soon as the prosecutor says state's case, you stand up, you look surprised. You say, well, my lord, if that's the case, I close, and sit down confidently. Okay? Now, you must learn how to look confident, okay, even when you're not. There's a bit of acting that goes on here. If you don't know how to act confident, well, go and take some acting lessons, okay? Or consult a friend who did speech and drama at university. You must confidently close, because you know that bringing an application for a discharge is likely to be refused. And when you then close, well, the judge might draw the adverse inference. So don't do it. If the state proved or presented admissible evidence that implicates your client, you have to respond. Then you only close if you know that your client's going to be even worse, or make it even worse. But if your client has a reasonably viable defense, you have to put your client in the witness box. Those of you who do a lot of criminal law will know that in this country, you often have accused persons who you know shouldn't be testifying, will insist. They'll insist. They'll say, I want to testify. I want to tell my story. Then you say, fine, these are the consequences. You are going to be cross-examined, but you want to testify, I will put you in the witness box. Okay? But many accused persons are quite savvy. They understand criminal cases. They know that if they take the stand, they're going to dig a hole for themselves, and you close. Okay? In a civil case, it's a bit different. To start off with, if you are the plaintiff and your witnesses went well, do not over-try a case. Over-trying a case is when you call more witnesses than is needed. So if your eyewitness goes really well, you don't have to call the other 3 witnesses. I explained that already. If you do call them, there are 2 risks. The first risk is that they'll undermine your best witness. But there's a second risk that the judge might find that you are over-trying the case, will get annoyed. Now, you must be smart, okay? Judges give you a hint. When a witness goes really well, and the judge can see this witness has presented proof of all the material facts, a judge might ask you a rhetorical question. Mr. Smith, do you have any further witnesses? The judge is saying, listen, just close and sit down now. But if you are South Africa's dumbest lawyer, you would say, yes, my lord, I'm calling Mr. Jones as my next witness, and watch, the judge will do this. It'll go like that. Because the judge is happy. It's going to find for you. You needn't push it now. Wants to hear the other side. What I'm saying to you, when you present evidence in a court, any court, criminal or civil, keep it short and keep it relevant. That's the secret. If you are over-trying a case, if you call too many witnesses, if you lead irrelevant evidence, you are going to get the judge annoyed. The judge will stop being on your side and you're in trouble. So, when you have to answer the question, do I close? The question of onus is still material. And in this case, when it comes to civil cases, you must look at the rule in Galante versus Dickinson. It's called the rule in Galante versus Dickinson. And it says this: in the case of a party himself who is available, as was the defendant in that case, it seems to me that the inference is at least obvious and strong that the party and his legal advisors are satisfied that, although he was obviously able to give material evidence as to the cause of the accident, he could not benefit and might well, because of facts known to himself, damage his case by giving evidence and subjecting himself to cross-examination. So in a civil case, if you manage to undermine your opponent's witnesses and the defendant is available, you might there decide that, listen, if I call this defendant, he's going to patch up all the holes that you made in the plaintiff's witnesses. It might be a better strategy not to call. And that's when you put on your actor's hat. When your opponent says, I close my case, you stand up and you look shocked. You say, well, my lord, if that's the case, I close. It's like saying, well, he's got such a rubbish case, I don't need to answer to it. Go and read Galante versus Dickinson. That's a very useful rule. Now, let's move on to the question of admissibility. It's one of the rules. If what is adduced can in law properly be placed before the court, we say that it is admissible. It is only once it has been or could be admitted. Now, evidence can only be persuasive if it is admitted into evidence. That's when the court is satisfied that you provide proof of the facta probanda, the material facts the plaintiff requires, or the material facts the defendant requires to satisfy the defense in the plea. Also note that admissibility of evidence is also determined with reference to its relevance. Remember, I told you the 3 yeses? First yes is relevance. It's always the first yes. You measure admissibilities and probabilities based on relevance. If a piece of evidence is not relevant to the dispute, it's not relevant in the sense that it is unhelpful to the judge, don't even bother with admissibility. Just throw it out. Don't even lead it. This is what relevance means. Bearing on or pertinent to the matter at hand. Evidence having tendency in reason to prove any material issue. Facts are relevant if from their existence inferences may properly be drawn as to the existence of a fact in dispute. In other words, relevance and evidence is relevant if it assists the judge with providing proof of a disputed fact. If it's not doing that, if it's unhelpful, it's not relevant, keep it out of a courtroom. And therefore, courts are strict about admitting evidence that is relevant. It prevents a proliferation of collateral issues and it saves time and costs. You know, you could end up leading something that's not relevant to the issues, but then your opponent now decides to make an issue out of it and now starts cross-examining and decides to call a witness to rebut it. All for nothing. It's just a waste of time. In deciding whether your evidence has provided proof of a fact, there's this concept of conclusive proof as against prima facie proof. You've all heard of prima facie proof or prima facie proof. What it amounts to is that it is proof that is subject to rebuttal by the other side. If that evidence is not rebutted, then prima facie proof becomes conclusive proof. Now, why is that so important in our courts? Because for certain types of remedy, you only need to provide the judge with prima facie proof, not conclusive proof. And where do we see that? In the motion courts. When you apply for any provisional order, then you only require to provide prima facie proof. But if you want the court to give you a final order, then you have to provide conclusive proof of your material facts. So prima facie proof implies that proof to the contrary is possible. This is proof, but is subject to rebuttal. In the absence of proof to the contrary, prima facie proof becomes conclusive proof. This is important where you proceed to court only for interim relief or a provisional order. Okay, I've explained that. Those of you who do urgent interdicts, this is important for you. Because if you go, for example, you bring an ex parte urgent, what you need, you are not going to ask for a final order. You are going to ask for a provisional order in terms of Part A of the notice of motion, and you will deal with, you will ask for a final order in terms of Part B. So when you bring the ex parte urgent application, you ask for an order in terms of Part A. Your founding affidavit only requires prima facie proof, not conclusive proof, okay? Now let's deal with hearsay. It means evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving the evidence. Okay? So all of you have an understanding of what is meant by hearsay. But what you need to know as a trial lawyer is how our courts approach hearsay now in the 21st century. What happened is this. The history of it started in the criminal courts, and it started in the Cape Flats. You know, the Cape is ridden with gang violence. It still is. For some reason they can't stop it. I don't know why. Maybe it has something to do with the fact that nobody there has front teeth or something like that, but there's just no way you can get rid of it. It became a problem for the prosecution that they put together a docket. They are ready to prosecute a gang member, and then the eyewitnesses disappear. They're either shot dead or they vanish. So now the prosecution is left with no case. But what they have in the docket are statements from those witnesses who have disappeared. But a statement cannot be handed in because it is hearsay. Its authenticity depends on the evidence of someone who is not in court. So they couldn't admit it. So what the legislation did, what Parliament did, they wanted to assist the prosecution and said, wait a minute, let's make an exception to the hearsay rule where a party whose witness has now disappeared has a signed original statement and can show that the witness is deceased or has disappeared, and under certain circumstances, that statement may be admitted into evidence. That's the Law of Evidence Amendment Act number 45 of 1988. Section 3(4). But if Parliament said that this exception applies only to prosecutors or the NPA, that would be unconstitutional because it will not be a law of general application. It will discriminate, and therefore, in order to make this act constitutionally legal, they made the exception to be applied throughout. Civil cases, criminal cases, all of them. So now you may use hearsay in court to prove a fact. The applicable section of the Act is here on the screen. It tells you, it provides for the parties to agree to admission. But what's more important for you is this. This is the test. This is what you are going to have to satisfy the court. Firstly, the nature of the proceedings. Why is this statement necessary to prove your case? The nature of the evidence. What is in that statement? The purpose for which you are tendering the statement. The probative value of the evidence. That means what material facts are you going to prove using the statement? The reason why the evidence is not given by the person upon whose credibility the probative value depends. In other words, the witness who signed the statement. Why is this person not available? For instance, you can say the person has deceased and you can bring a certificate, or you can lead evidence that this person has disappeared, or tell the judge what steps were taken in order to locate this person. Any prejudice to a party which the admission of such evidence might entail, that really amounts to legal argument. Any other factor which, in the opinion of the court, should be taken into account is of the opinion that such evidence should be admitted in the interests of justice. Now, these are requirements that can easily be met. But there's a judgment. It's the Metadad case, where the judge said the following, and it gives you an indication. I think it was Rex van Schalkwyk who said this, but it gives an indication of where judges are going with hearsay evidence. You know, when we were at university, we were taught that hearsay evidence is taboo. You just can't, just forget it. It'll be objected to, it'll be struck out, and so on. This section invests the court with a discretion to be judicially exercised in the interests of justice. It seems to me that the purpose of the amendment was to permit hearsay evidence in certain circumstances, where the application of rigid and somewhat archaic principles might frustrate the interests of justice. Now, the rigid and archaic principles are those principles which say hearsay evidence, taboo. The exclusion of the hearsay statement of an otherwise reliable person whose testimony cannot be obtained might be a far greater injustice than any uncertainty which may result from its admission. That's a very powerful argument for the admission of a statement. So you have two things backing you now. You've got, if you have to use a signed statement, you have two very powerful arguments. The one argument is that there's legislation that supports it. And if you can satisfy the requirements of the legislation, the judge must admit the statement. But now you also have common law support. You've got the decision of a court that says this is authority that you may admit it. So the section introduces a high degree of flexibility to the admission of the hearsay evidence, with the ultimate goal of doing what the interests of justice require. Now, I'll give you an example. So when can you use this rule? You can't use this rule in argument. You cannot use this rule to ambush your opponent. It must be transparent. For example, in a criminal case, and prosecutors use this section all the time, an accused cannot be ambushed by the late or unheralded admission of hearsay evidence. The trial court must be asked clearly and timeously to consider and rule on its admissibility. You see, if you have a statement, if the prosecutor has a statement, the prosecutor can't merely hand it up and admit it into evidence. The prosecutor has to show that they can comply with the requirements of the Act, and then the judge or magistrate must make a ruling on the admissibility. It's not an automatic admission into evidence. So the judge has to make a ruling. This cannot be done for the first time at the end of the trial, nor in argument, still less in the court's judgment, nor on appeal. The prosecution, before closing its case, must clearly signal its intention to invoke the provisions of the Act, and before the state's case closes, the trial judge must rule on admissibility, so the accused can appreciate the full evidentiary ambit of what he or she faces. So this is not a free ticket to leading hearsay evidence, but it is certainly makes inroads against the rule. It is highly useful and you should use it. So in a civil case, here's a judgment. The court held that the position should be no different in a civil proceeding. The appellant's contention was, however, that the court had heard the difference between the two, so the appellant argued, is that in criminal proceedings, effect must be given to the constitutional right of an accused to a fair trial, whereas that doesn't apply in a civil case. Well, that's wrong. You are equally entitled to a fair trial in a civil case, which is expressed in the uniform rules and the rules of evidence. So the statement in a signed statement of a witness that has disappeared can be used in a civil case. Now, I'll give you an example. I was in a case where the plaintiff sued the police for damages, where the plaintiff was shot by the police and sustained serious injury. And plaintiff claimed to be a passerby. They sued. The eyewitness who there were eyewitnesses. This happened in the street in Jeppe somewhere. So there are a lot of people around. And there were eyewitnesses. When the matter came to trial, the eyewitnesses disappeared. They couldn't find them. Tried everything. The attorney, plaintiff's attorney, was pretty sharp, was very, very clever attorney. He realized that because this was a shooting involving a police officer, there must be a docket somewhere. So he went off to the Jeppe police station and he found this docket. And in the docket were signed statements from the two witnesses who had disappeared. He brought them to court, was able to comply with the requirements of the act, and it was admitted into evidence. He won the case. In terms of Rule 39, the defendant is afforded the right, where the plaintiff bears the onus, to apply for absolution. Now, I've dealt with this. It's a useful thing, but judges will only grant you an absolution where you can show, on an analysis of the evidence led by the plaintiff, they have not provided proof of the facts, the facta probanda, which supports their cause of action. Okay. Now, I want to go through quickly the rules, some of the rules of evidence. We've been through most of it. The first rule always is relevance. Please remember that. If you're consulting and your client gives you some information and you can't work out what the relevance is, or it is irrelevant, stop them and say, oh, listen, let's bring you back. Let's deal with what's relevant to your problem. And clients, by the way, they lay people. And when they lie, and they enjoy telling the attorney or the advocate a story, but they don't understand this called relevance. Okay, it's up to you to manage that. The evidence must be relevant to an issue. There must be a question to be decided. The evidence must be helpful to court. The evidence must help the court to answer the question. Then it's relevant. Then you've heard about the materiality of evidence. The evidence must be material. What that means is the evidence must be relevant and important. The evidence must support your case concept. That is very important. The second one. You know what your case concept is. It is what happened according to your client's version of the facts. Your evidence will be material if it supports that case concept. And then there's admissibility, we just dealt with. Relevant is evidence is admissible unless excluded by a rule. Now, that is what we all learned as the golden rule of evidence. I mean, everyone swatted it off without understanding it. Hearsay, character, similar fact evidence, opinion. That is excluded, okay? I'll say a little more about character and similar fact in a moment. Improperly obtained evidence is excluded, it's inadmissible. And when considering admissibility, a judge will consider probative value weighed against prejudice. So whether or not this evidence is admissible, a judge will also consider what is its weight as proof of a fact. If it has no weight as proof of a relevant fact, a judge is going to say it's inadmissible. Why? Because it's not relevant. So relevance comes in again. Now, let's look at findings of fact. Presenting evidence is about presenting proof of the facts. You need to understand how fact-finding happens after the judge hears the evidence, okay? Now, I can tell you, judges don't sit there with a blank mind. They are already making up their minds from the moment they read the papers. So when a judge walks into court, the judge knows what the issue is. Now the judge wants to see or determine if the party bearing the onus discharges it. But what happens is the judge in a trial will hear opposing versions. His job is to decide which version to accept or which version is persuasive. Now, fact to a judge in determining a matter means proof to the satisfaction of the court. We dealt with that already. Now, in making findings of fact, two basic principles must be kept in mind. The evidence must be weighed in its totality, not piecemeal. You can take a single witness and say, you can't believe this witness, and here are the reasons. But in the final analysis, the judge will say, let me consider all the evidence, and then I'll make a decision. Probabilities and inferences must be distinguished from conjecture or speculation. That's very important. What judges are looking for are testing the probabilities, and they are drawing inferences from the proved facts. If the judge is now going to make findings that are not supported by the evidence, that amounts to speculation. Can't do that. If a judge draws an inference, the judge has to say, I draw the inference from the following proved facts or evidence. Otherwise, the judge cannot make inferences. The inferences must be drawn and must be supported by the proved facts. In other words, facts that amount to proof to the satisfaction of the court. So, what's the judge doing? In an adversarial hearing, the judge makes a finding only on the evidence. We've been through that. Findings of fact and probabilities are made by evaluating each witness. Now, here is the important stuff. The judge doesn't merely test the version. First, the judge must be satisfied that the witness presenting the evidence is credible. So that's the first test. Now, you know, if a witness turns up and is quite patently a liar or gives you a bizarre version in the first place, this witness cannot be believed. There's absolutely no point in measuring the witness's version based on credibility. Why? I mean, you just throw it out. The witness has no credibility, so how can the version be either probable or improbable? How reliable is the witness? I dealt with that. Did this witness have a proper opportunity to see what happened? Now, if the witness passes credibility and reliability, then the judge says, how probable is this version in relation to the facts of the case? Now, with credibility, these are the tests. Now, there are some useful decisions there. And in my book on trial advocacy, I take you through this very carefully and show you how you deal with it when you're on your feet in court. Firstly, there's this thing called general impressions and demeanor. Now, what that is the impression the witness creates on the judge who is sitting in court and observing the witness. Now, there's a debate that's going on, and it's not settled, as to whether or not demeanor is a reliable indicator of the truth. Some judges think a witness's demeanor does indicate whether this is a credible witness or not. There are other judges who think, well, the demeanor is not good, but that may be because the witness is just nervous. I mean, people get nervous in court. It doesn't mean that they're not credible. So it depends on the judge. You must be, if you know the bench where you practice, you will know which are the judges who take demeanor seriously and which are ones who don't. When you're in front of a judge who takes demeanor seriously, you must have prepared your witness very well. Then there's things like veracity, candor, bias. Bias is very important. If the witness has some interest in the case, it undermines credibility. Contradictions, we all know that is a really serious indicator of credibility. Like someone mentioned yesterday, that an accused changes the version, contradicts the version that was put by the defense attorney to the state's witnesses. Now, this happens all the time. That is a clear indicator that there's something that this version or this witness is not credible. External contradictions of established facts. What that means is it's common cause that there was load shedding that night and all the lights were off. But the witness testifies that he was able to see because the street lights were on. So these are fairly material contradictions. And this one we just discussed, his version put to witnesses. That can happen in a civil trial as well. The probability or improbability of aspects of his version. Now, when judges test probabilities, it's not the case of the overall probabilities of the version, bearing in mind the circumstances of the case. It may be that the judge is testing an aspect of the version, whether that is probable or not. Okay, like, is it probable that the surety signed the suretyship in the presence of witnesses when he claims he had a gun held to his head? Is that probable? The cogency of the performance of one witness compared to the other. Okay. Reliability is important. You're looking for time, distance, lighting, weather, view, knowledge. These are factors that you will use in cross-examining your opponent's witness to undermine reliability. Okay. Now, I deal with this comprehensively in my book on trial advocacy. One of the problems that lawyers make is that when you cross-examine, your purpose in cross-examine is to bring out facts that will enable you to present final argument. You do not want to cross-examine to bring out any conclusions, only fact. So, for example, you say to a witness who identified your client, to say, Mr. Mokoena, it was 8 o'clock at night. Yes. The sun had already set. Yes. You are standing across the road from where the incident took place. Yes. You were about 15 meters away. Yes. It was already dark. Yes. So it was too dark for you to see my client. No, there was enough light. I saw who it was. Do you see how stupid that last question is? You stop before that question, and now you can argue and say to the judge, this is not a reliable witness. Look at his evidence. He admits it was dark. It was after 8. He was standing far away. You now argue what the conclusion is. His identification is unreliable. Okay? So never test reliability and then expect the witness to say, oh, you got me, I was unreliable, I didn't see. That never happens. Now, I've dealt with this extensively. You can read it again. It's on the probabilities. Your function is to present the evidence in such a manner as to persuade the judge to accept your witness's version. Okay? Now, there's this thing, the criminal standard. I have to deal with it because it's most misunderstood. Onus is on the state. That's not a problem. When does the state discharge the onus? How does a court test it? What is the method? The judge never looks at the evidence in isolation. All the proved facts are considered, and then the question is asked, did the state discharge the onus beyond reasonable doubt? The degree, now, what is meant by beyond reasonable doubt? The degree of cogency which the evidence on a criminal charge must reach before the accused can be convicted. Now, that doesn't tell you much. It's a very technical explanation. Now, when you say, when someone says the state failed to discharge its onus of proof beyond reasonable doubt, all they're saying is that the state did not provide sufficient proof, that the state did not convincingly prove the material facts of the charge. Now, what I want to do is to give you a very good understanding of what is proof beyond reasonable doubt. I found this passage from Lord Denning. Lord Denning was an English judge. He was an incredible jurist. I mean, he wrote some amazing judgments. Those of you who are serious about law, you should go and read some of Lord Denning's judgments or writing. Listen to this. I mean, think about it. Has anyone been really able to tell you what is meant by proof beyond reasonable doubt? Listen to this. The degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Do you see that? It doesn't have to be the truth. It doesn't have to be certain, but it must have a high degree of probability. Proof beyond reasonable doubt does not mean beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect justice. Do you see? The judge is not saying what's possible, it's what's probable. And if you can come up with any stupid reason for having committed an offense and get away with it, then where's the protection? If evidence is so strong, and here's the key, if evidence is so strong against a man, and includes women, as to leave only a remote possibility in his favor, which can be dismissed with the sentence, of course it's possible, but not least probable, the case is proved beyond reasonable doubt. But nothing short of that will suffice. It's absolutely brilliant, this explanation. It's in your notes. Go read it again. Those of you who do criminal law, there it is. It comes from the judgment in Miller versus the Minister of Pensions. Okay, so benefit of the doubt. So what is that? Where does it come from? It comes from jury trials. A jury is made up of lay people, okay? It's members of the public. They are not trained lawyers. They don't understand onus. They don't understand proof of a fact. So what happened with jury trials? The judge will give them instructions before they go and consider their verdict. And the judge will then say to them, if there's a doubt, then give the accused the benefit of the doubt. It simply means that if a court is left in any degree of doubt whether the accused is guilty, then the case has not been proved. If it is doubtful that the state proved an essential fact, or the existence of a fact is doubtful, the state has failed to discharge its onus. Basically means the same thing. Look at the material facts that need to be proved to satisfy the legal requirements of the offense. If one of those material facts has not been proved, it's in doubt. Okay. All right. This is the last section that I want to deal with. And that's experts. Now, you can't practice in our courts if you don't know how to deal with experts. And again, I dealt with this comprehensively in my book on trial advocacy. It's all you need to know. It's in that book. These are not factual witnesses. They present the court with an opinion to assist the court because the court does not have the knowledge nor the expertise in that particular field. It's a technical field. One of the things in modern dispute resolution, you always consult the expert at the beginning. When you see the need for an expert, consult the expert before you issue the summons. Now, traditionally, I practiced as an attorney. We never bothered about an expert. We went and looked for an expert after the pleadings closed and we got a trial date. Now we start sending out summaries and notices and so on. It's too late. In Gauteng, in the local division here in Johannesburg, you are expected to indicate to the registrar when you issue a summons whether or not you'll be using experts. If you are using an expert, there'll be a capital E next to your case number so that the case managers know that this case involves experts. You also need to know if you're going to call an expert is for purposes of budgeting. Now remember, if you took on a case on a contingency, you will have to pay as the law firm for the services of an expert. Although contingency litigation has reached such a state these days that there are many experts out there who also do it on a contingency, but the firm is always at risk. Engage at the earliest possible time. Do not go looking for an expert after pleadings close. You see, an expert can advise you on the merits of the case, and they can advise you on your course of action. That is why you talk to an expert before you write your particulars of claim. And when you engage an expert early, always ask the expert if they will testify in court. There are many experts who will give you a report and charge you a fortune for it, but then they'll tell you, I don't appear in court. What that means is, for the trial, you'll have to engage another expert who will charge you to study the first expert's opinion and then go and give evidence. It's double the costs. The other advantage in calling the expert early is you get what we lawyers call a first choice expert. In other words, the best one that's available. And in this country, it matters. We have a shortage of experts. In some disciplines, you might have only one expert in the country. And if you don't get that expert on your side, you'll have to get one from outside. You'll have to fly one in from England or somewhere, and it's very costly. Okay. Always do a due diligence on your experts. Check if they are properly experts. You have to manage experts from the start. If you don't manage them well, you will lose money and you could even lose your case. Now, in our courts, in fact, through all the high courts, there are practice directives which tell you how to manage experts. And the purpose of those directives is to try and avoid calling experts if it's possible, because experts cost a lot of money. They take a lot of time. So therefore, you're all familiar with these directives. The experts, once the summaries and reports have been exchanged, they must meet. In the absence of the attorneys, they must hold a meeting and come up with a joint minute where they are to try and settle as many issues as possible. And very often, in fact, I would say 60% of the time, or possibly more, the experts don't dispute one another's evidence. They agree, and all you need in court is to hand up the joint minutes and the reports. You don't have to call them. Now, if you don't comply with those directives, most of our courts, they will refuse to give you a trial date. You must, when you apply for a trial date, you must send in the minutes of the pretrial conference, an estimation of the duration of the trial, and the joint minutes of the experts. Like in Gauteng, here in Johannesburg, the case number will now tell the registrar this is a case involving experts. So he looks at it and says there's no minutes. So he'll send a note to the attorneys and says, I'm not giving you a date, go and comply with the directive. Okay. So what I've done here, go and read through this. I've showed you, I gave you a formula of how experts come to their opinions. Now, there are two things an expert looks at. The expert obviously has to apply his discipline. He's an engineer or an actuary or a surgeon. Those are the skills he has to apply. But no opinion can be given in a vacuum. In other words, no one can say, listen, I'm an engineer, let me tell you what happens. It has to be related to the facts of the case. Now we're back to the facts. You've got to link in the opinion to the facts of the case. And that's where the experts go wrong. And that's where you can challenge them. How does this work? You cannot cross-examine an expert effectively on his qualifications. There you got no chance, unless this expert is a chancer himself, which never happens, not these days. The only weakness where you can cross-examine is the facts which was given to the expert. What are the facts that he used? What are the observations that he made? And there you will find the opportunity to cross-examine. Very often, the facts used by experts, the evidence is given to them by an attorney, the instructing attorney. So the quality of that opinion depends on the quality of the facts given by the attorney, and that's where you can undermine them. Okay? So I've set out a set of techniques on how to cross-examine a witness. I would suggest you should get this book of mine. It's available from next week. Betty will give you the order forms. Someone just asked now if the book is available. It is available. You can just put in an order with LexisNexis. Now, similar fact evidence, as you know, judges say it's got no probative value and is therefore excluded. What it means is just because someone did something similar previously is not proof that he did it again. Likewise, when you deal with criminal cases, this is the reason why the person's previous convictions are not admitted into evidence until after the verdict is given. So if there's a conviction, only for purposes of sentencing will the previous convictions be provided. You cannot use, if you charge someone for drunken driving, you cannot say that, well, look at this. He's been charged 3 times for drunken driving, so therefore he must have been drunk this time. Now, the exception to this, you can use similar fact if it has probative value. When will it have probative value? If it can show that it is relevant to the modus operandi of the person, the accused, or the defendant. Then for that purpose, it will be admitted. Otherwise, it can result in collateral issues and it becomes unnecessarily lengthy, the trial. So the courts expect a high degree of relevance before admission of similar fact evidence. So if it's modus operandi, then that must be relevant to an issue before the court. And this is what Lord Denning said. It should not be admitted unless its value as proof warrants its reception in the interests of justice, and its admission does not operate unfairly against the other party. A particularly compelling consideration in criminal cases. That's, I say, the brilliant Lord Denning. Seriously, you guys should go and read Lord Denning. In criminal cases, the rule is the prosecution may not adduce evidence of improper conduct by the accused if its only relevance is to show the accused is of bad character and is therefore likely to have committed the offense. It's what has become known as the Macon formulation, okay? And I'm not going to take you to the parallel evidence rule, where you are not allowed to lead oral evidence in contradicting what the parties agreed to in writing in a contract, okay? But this is fairly straightforward stuff, and I'll expect you to read this on your own. I want to now go quickly to your questions before I run out of time altogether. Have you sent them, Betty? Let's have a look.
Judge, I have just sent them. I didn't want to disturb you while you were speaking.
No, you should have sent them. I used multiple screens. So, by the way, it's a good idea to use multiple screens. It saves you an enormous amount of time as a practitioner. Have at least 2 screens, so you don't end up having to keep clicking on the taskbar between documents. It takes up too much of your time. Okay, now I'm still waiting for these questions to come through. I just want to remind you of a few things. Later, Betty, what's the date for the opinion writing thing? I've got it here somewhere. Oh,
I think it's 23, 24.
23, 24 June, eh? This month.
That's correct. That's correct.
There's a webinar that I'm presenting on writing opinions. That's very much part of what lawyers do. I take you through a method whereby you can write opinions quickly, write it, and I'll show you what the modern business want from opinions, how to write short opinions, how to research effectively and quickly. All of that very practical stuff is going to come in that course. So I would recommend that you attend it, or tell your colleagues if they're doing a lot of opinion work to look at it. The details you will get from Betty. And then you will also receive the order forms and brochures for my books. The trial advocacy book was printed this week, so it's hot off the press. But Lexis have been taking advance orders, and it's available from next week. It should be on the shelves. It's a very comprehensive treatment of what you need in a trial. Betty, this thing's not coming through. Has it gone into my spam box again?
Judge Hussain, Merlin will also send it to you.
Okay. No, it's not in the spam. Boy, that's taking long, eh? Ah, there we go. Here's question 1. Oh, there they are. Okay. Sipo Shongwane says, is there a difference between an admission of a document and admission of the contents of the document? One is often meant with the following statement at pre-trial: so-and-so admit the document is what it purports to be, but does not admit the contents thereof. Yeah, you admit the document as it is. What that means is you don't have to produce the original. We can admit that into court, but there's no admission as to the truthfulness of the content, because that may be an issue. So that's when you say this. And so the document itself may be put in the bundle and handed in, but the contents thereof, you will have to lead evidence. Regarding bare denials and cross-examination, is a lawyer for a party that made a bare denial allowed to admit that he is not entitled to put a version, but argue that he is entitled to cross-examine so as to test the veracity of the witness's version? Lastly, regarding skid marks, how have courts dealt with the SCA's finding in the Ngueba case that a court cannot draw an inference about the speed of a motor vehicle merely from the skid marks? Yes, let me answer the first question first. If there was a bare denial, now please just do this properly. When your opponent pleads a bare denial, don't let them get away with it. You take exception. You say this does not disclose a defense. It's a bare denial. Take exception. But before you take exception, send them a notice to remove a cause of complaint, to say there's no defense here. And if you don't amend, I'm going to take exception. What happens here in our courts? The attorneys are quite blasé about the pleadings. They don't even bother to read their own pleadings. So there's a bare denial in the pleadings, and now they go to court. And then what happens? The lawyer now puts a version to your witness, but that version is not pleaded. They pleaded a bare denial. So you stand up and you say, objection, my lord. This is not pleaded. The objection will be upheld. But then what will happen? Your opponent will say, my lord, I need to amend my plea. What does that lead to? A postponement and wasted costs. So don't go to court with your opponent who has filed a bare denial. You tell the opponent there's no defense. Now, before you take exception, you may also say to your opponent, look here, we are going to arrange a meeting with a judicial manager, a judge, and on the agenda, you'll say, we are going to tell the judge that you have disclosed no defense. Okay, so to avoid an exception, we are going to ask the judge to make a ruling. So that deals with it. But if you ended up in court and the attorney says, I put it to you, but it's not pleaded, just stand up and say objection, and it will be upheld. The drawing of inferences from skid marks, well, it will require an expert to say, what's the difference? What kind of skid mark, what length will be expected to be made, bearing in mind the velocity of the car, when the brakes were applied, and so on. That might require expert evidence. But you don't need an expert to work out the probabilities. Now, this judgment, I haven't read it, but if a judge says on the probabilities, this car could not have been doing 30 or 60, they don't need an expert to tell you that. Okay. The next question is, what is your stance when a defendant states on his plea explanation, oh, the contents of this paragraph is noted. This is such a lot of rubbish. I've seen this all the time. I see it even today, where someone says, at paragraph 4, the allegations are noted. So what does it say? What's noted? Now, I'll tell you, look at the uniform rules. Rule 22, I think, deals with the plea. The only way you can respond to a plea is you can admit a fact, you can deny a fact, you can confess and avoid, and fourthly, you can state the facts of your defense. 4 things. It doesn't say anywhere there that you can say noted. When you say noted, noted means if the judge reads noted, the judge reads admitted. It'll be treated as admitted. So writing noted serves absolutely no purpose. You know where it comes from? Do you know why you see this in so many pleadings? It's because the attorneys all use the same rubbish precedent. That's why. Just stop it. Okay. Do you have to call the client? Can you choose not to call the client? In other words, in order to call other witnesses, do you have to call your client first? Yes. In criminal cases, yes. You have to call your client first, the accused. In the civil cases, you can call witnesses in any order you like. The advice I give you in civil cases, always start with your best witness, not the one who's sitting outside court. It's not about who's available. It's about who's the best. If your best witness is not there, ask for a short adjournment until he turns up. Okay. Baliwe wants to know how to adduce evidence in court as a lawyer, or what are the basic layout that a lawyer should ask a witness. That's a long answer. I tell you what, I'm not trying to sell you my book, but it's dealt with comprehensively in that book. For instance, yesterday someone said, can you put the chronology document of your witness in front of the witness? Now, this is how you deal with that situation. When you're preparing your witness to give evidence, give your witness his statement that you took down, which is signed, to refresh the memories. Then you give the witness the chronology document and say, read through that. The witness will see, well, this is my version, these are the main points, and this is the time, the sequence. Then you say to the witness, that is the sequence in which I'm going to ask you. That's how I'm going to ask you questions. And it is permissible if you say to your opponent, can I hand my chronology document to the witness? If he says fine, fine. If he says no, not a problem, okay? But I've seen cases where the judge allowed the chronology document to be placed in front of the witness. It's not the statement, okay? Van Niekerk says, in a criminal case where the charge is rape, the complainant alleges rape and the accused alleges consent and gives a plea explanation to that effect. The complainant is a single witness. Would you recommend closing your case after the state closed their case? Oh, no. Oh, no. Listen, there's case law now that deals with the issue of single witness in a criminal case, okay? Now, there used to be this cautionary rule. There's a constitutional court decision, or it could be SCA, which said that, yeah, it's constitutional court, that there's no such thing as a cautionary rule, that in an offense, a sexually related offense, you have to apply a cautionary rule because the witness has a personal and private knowledge of what happened and is therefore a dangerous witness and can falsely implicate an accused. That's outlawed. But I can assure you, most judges are aware that it's a single witness. But in our rules of evidence, in the Criminal Procedures Act, a person may be convicted on the evidence of a single, credible, reliable witness. Now, if that witness is credible, if you did not make inroads in cross-examination, if you close, your client will be convicted. But if you made inroads, if you damaged this witness under cross-examination, and you know that your client is going to mess it up if he gives evidence, then you tell your client, I don't want you to testify. If your client insists on testifying, you say, give me a mandate in writing that you want to testify against my advice, put him in the box and let him convict himself, okay? Now, here's a long question here from Terence. In a collision situation, the paramedics come to the scene and start assisting the victim. In the process, they inquire on what happened. And he tells the paramedics that he fell. The version is recorded in the records, and it is recorded that the paramedics related the information. The victim brings a hit and run claim. He was obstructed and forced braking, slipped and fell on a wet road. Police arrive and ask what happened. Listen, Terence, this question I don't understand. It's just too involved. There's another thing about being a lawyer. You must learn to ask short, sharp questions. I know you're trying to present a scene, but I really can't deal with it. I've got 5 minutes left. Contributory negligence, is it correct to say if the defendant raised the defense of contributory negligence, the plaintiff is only required to prove 1% negligence, and the defendant now has the onus to prove contributory negligence? Yeah, that's right. Contributory negligence is where, well, there's the act, Apportionment of Damages Act. You need to comply with that. In delictual damages, in delictual cases, often both the parties contributed towards the incident. In other words, both parties were negligent. What you have to be very careful of as the plaintiff is to lead evidence to show that the defendant was the principal cause, the defendant's negligence, and not the plaintiff's negligence. And that's how you deal with it. Okay, let's check. I don't think there's any more. Oh, there we go. There's two more questions here. Lorraine Nell, in a matter where the witness testified that the other party bragging about him assaulting many women before, does that only amount to character evidence, or may it be argued as similar facts? Also, how can we better deal with a bare denial tendered by an attorney in a criminal case? Okay, two facets to this question. The fact that somebody was bragging about assaulting many women, that would be excluded unless it becomes relevant to show that there's a modus operandi. You'll have to tell the judge that there's a modus operandi here, and it's relevant to the issue, and then you may be allowed to lead this evidence. But this is character evidence and similar fact evidence, okay? Where, now in a criminal case, you see this happening all the time. There's this overblown right to your right not to make any statement, your right not to disclose your defense. In most criminal cases, the accused will tell the lawyer not to make a 115 statement. I can tell you, when you say to a judge, my client elects his constitutional right to remain silent. Now that sounds very impressive. Guess what? The judge is sitting there and saying, oh, so you want to remain silent? I don't think you've got a defense, eh? Because if you had a defense, you'll tell me about it. You'll shout it from the rooftops, not staying, remain silent. When you remain silent in a criminal court, take it from me, you are on the back foot. The judge or the magistrate is not with you. They want to hear the first witness for the defense. You've just wasted their time. But if you made a 115 and you told the judge, listen, here's my defense. This is what happened. The judge is thinking, oh, that sounds like a defense. I think this guy might well have a defense. And now the judge is with you, okay? But this business of remaining silent doesn't work. But I'm not taking an ivory tower view. You will have many cases where you just don't have a version, okay? Then you must remain silent, and then you must test the state's case. That's all you're going to do. Nkosi Robin says, can you please comment on admissibility of similar fact evidence or character in bail application? Listen, the same rules apply, except in bail applications, they're a bit more easy about it. A lot of hearsay gets thrown in, nobody objects. You must decide whether you want to call the witness to testify in a bail application, the accused, or you want to submit an affidavit. Now, I'll tell you, it's a very dangerous thing to call your client as a witness in a bail application, especially if it's a scheduled offense. Chances are that he'll be cross-examined into showing that there are no exceptional circumstances and you will not get bail. The better option is to use an affidavit. The state will call the investigating officer and you can cross-examine. But just remember, there's some leeway in using similar fact, especially with modus operandi. It's highly relevant in a bail application. And so can character evidence be relevant. But you have to make the state has to set a basis for it first. But similar fact, with modus operandi, you see this being led by the state in bail applications all the time, okay? Like people who are serial offenders, modus operandi. Okay, I think that does I think those are the questions for now. Well, my time is up. I hope you enjoyed this course. Please go and read the notes again. And if you read those notes in combination with what's done in my book, it takes you through every aspect of a trial. You won't believe the detail with which I've dealt with that book, or in that book. It's once, if you read it cover to cover, you're good to go. It just guides you on everything. There's also a series of short webinars that I'm giving. Just contact Betty Lubber. There are 4 of them. They're short, but it deals with aspects of the trial. How to prepare, what to do in a trial, how do you make a opening statement, how do you lead a witness in chief, what do you do in cross-examination, and your final argument. It's useful, it's not expensive. I think it's because they're short webinars, and you could attend any one you choose. You don't have to attend all 4. Okay, good luck to you, and please practice the techniques. All the stuff I'm telling you is tried and tested. Practice, and you'll get really good. There's no more room in the profession for mediocre lawyers. You need to be really good to succeed, okay? There's plenty of competition among the bad lawyers. Trust me, there's not much competition among good lawyers. There's a shortage of good lawyers. You might think I'm talking nonsense, but I know the profession. There's an oversupply of really poor lawyers, okay? If you want to succeed, turn yourself into an excellent lawyer. These techniques I showed you will assist you. Okay, that does it. Thank you, everyone. I'm going to leave now, Betty.
Thank you so much for your time, Judge Hussain. It's appreciated.
Thank you.